They say possession is 9/10 of the law. What they don't tell you is that in intellectual property, ownership is all 10/10, and discovering you have it at exactly the moment someone tries to keep you from leaving is a beautiful kind of leverage. I learned that in a corner office on the 41st floor, where the furniture was expensive and the view was supposed to make you feel grateful for the opportunity to work there. I'd come to resign, to walk away from 6 years of innovation that had been systematically undervalued and undercompensated. What I discovered instead was that the technology I'd built, the patents I'd filed, the intellectual property that formed the foundation of the company's entire product line, belonged to me, not to them, and that changed everything. My name is Dr. Elena Vasquez, and I used to be the Chief Technology Officer at Novus Biotech, a medical device company that had built its entire business model around diagnostic technology I'd invented in my university lab before I'd ever joined the company. Used to be, because on a Tuesday morning in March, I walked into CEO Catherine Chen's office to tender my resignation, and walked out 30 minutes later with the realization that the company's continued existence depended entirely on my goodwill. The tension had been building for months. Novus had been founded on my technology, a novel biosensor platform that could detect multiple disease markers simultaneously from a single drop of blood. Revolutionary when I developed it during my postdoc, still cutting edge 6 years later, and the basis for every product Novus had brought to market. The science behind it was elegant. Traditional biosensors could detect one marker at a time, requiring multiple tests and multiple blood draws. My platform used a unique array of functionalized nanoparticles that could simultaneously bind to dozens of different disease biomarkers, with optical detection that could distinguish between them in real time. The implications for point-of-care diagnostics were enormous. Single-test screening for multiple conditions, rapid diagnosis in emergency settings, continuous monitoring of chronic diseases. I'd published the initial research during my postdoc at MIT, then spent 2 years refining the technology in my own university lab before Catherine had approached me about commercializing it. She'd seen the potential immediately, not just the scientific elegance, but the market opportunity. Healthcare systems were desperate for better diagnostic tools. Insurance companies would pay premium prices for technology that could catch diseases earlier when treatment was more effective and less expensive. I'd joined as a co-founder, lured from academia by Catherine's pitch about building something that would change healthcare, about the impact we could have together, about equity and partnership and shared vision. She'd been compelling, a former pharmaceutical executive with connections to hospital systems and investors, someone who understood regulatory pathways and commercial strategy in ways that I didn't. The reality had been different, slower, more political, more focused on fundraising and revenue projections than on the scientific vision that had attracted me in the first place. Catherine was brilliant at raising money, at pitching to investors, at navigating the business side of healthcare. But she didn't understand the science deeply, and increasingly, she didn't seem to care about understanding it. The technology was a tool for building a company, not an end in itself. The first disagreements had been about the product roadmap. I'd wanted to develop more sophisticated versions of the platform, to expand its capabilities, to push toward the kind of comprehensive diagnostic tool that could replace dozens of separate tests. Catherine had wanted to focus on simpler applications that could get to market faster, single disease tests that used the platform but didn't leverage its full potential. We need revenue, she'd argued. Comprehensive diagnostics are great as a long-term vision, but investors want to see commercial traction now. We build the simple products first, prove the market, then expand to more ambitious applications. If we only build simple products, we're not differentiating from competitors. Anyone can make a glucose monitor or a pregnancy test. The value of this platform is its ability to do things that nothing else can do. And we'll get there, but we need to survive long enough to get there, which means generating revenue from products we can bring to market in 18 months rather than 5 years. She'd won those arguments, as she'd won most arguments about commercial strategy. I was the CTO, not the CEO. My job was to build what the company decided to build, not to set the direction. The breaking point had come during our Series C funding round. Catherine had been negotiating with investors, and I'd learned through documents I'd seen by accident that she'd been systematically understating my role in the company's technology development. Presentations to investors described the biosensor platform as internally developed technology, without mentioning that it was based on my original invention. Patent filings listed me as one of several inventors on improvements to the platform, but somehow the fundamental patents, the ones that made everything else possible, were treated as company assets that had existed before I'd arrived. I'd confronted her about it during a product review meeting, pulling up the investor deck on the conference room screen. This says the core technology was developed by the Novus engineering team. That's not accurate. It was developed by me at the university before this company existed. We've built on your original work extensively. The products we're selling today are quite different from your academic research. They're different in the details, but they are built on the same fundamental platform. The nanoparticle array, the optical detection system, the multiplexing architecture, that's all from my original patents, which you licensed to Novus when you joined. The technology belongs to the company now. I licensed it. I didn't transfer ownership. There's a difference. A technical difference that doesn't matter operationally. The company has rights to commercialize the technology. That's what matters to investors. It matters to me whether I get credit for inventing something. And it definitely matters legally which entity owns the patents. Catherine had ended the meeting without resolution, and I'd left frustrated, feeling like my contributions were being erased from the company's history. Not because of malice, necessarily. Catherine genuinely seemed to believe that once technology was licensed to a company, the distinction between licensing and ownership stopped mattering. But to me, the distinction was everything, except they hadn't. I'd developed the core technology at the university, filed provisional patents before leaving academia, and then licensed the technology to Novus when I'd joined as co-founder. The license agreement was generous, exclusive rights for Novus to commercialize the technology in exchange for founder equity and the CTO position. But it was still a license, not a transfer of ownership. I'd pulled the original agreements, read them carefully for the first time in 6 years, and realized something I'd forgotten, or perhaps never fully understood. I owned the foundational patents. Novus had rights to use them, but I retained ownership. And buried in the license agreement was a clause I'd insisted on during the original negotiation, back when I'd been naive enough to think it would never matter. If I left the company, the license could be terminated with 1 year's notice. 1 year. 12 months for Novus to find a way to operate without the technology that their entire product line depended on, or to negotiate new terms with me, or to watch their business collapse because nothing they made could legally be manufactured once the license expired. I'd drafted the resignation letter carefully, professionally, with no hint of the leverage I'd discovered. 2 weeks' notice, standard language about appreciating the opportunity, expressing hope that the company would continue to thrive. I'd scheduled a meeting with Catherine, walked into her office on that Tuesday morning, and handed her the letter. She'd read it, looked up with an expression of mild surprise. "This is unexpected. Is there a specific issue we should discuss? I don't think my role here aligns with my career goals anymore. I've been offered a position at a research institution that's a better fit for where I want to be." It was true. Stanford had reached out about a faculty position, offering me the chance to return to pure research, to work on problems that interested me, without the pressure of quarterly earnings or investor expectations. The offer had crystallized something I'd been feeling for months. I miss science. I'd spent 6 years building a company when what I really wanted was to build knowledge. Elena, you're critical to Novus. Losing you would be a significant setback. What would it take to keep you? I don't think it's about compensation. It's about what I want to be doing with my career. Catherine leaned back, studied me with the calculating expression I'd seen her use in negotiations with investors and partners. "I'm not accepting your resignation." "I'm sorry? Your resignation. I'm not accepting it. You're too important to the company. We need to find a way to make this work." "Catherine, that's not how resignations work. I'm giving you notice that I'm leaving. I'm not asking permission. And I'm telling you that your departure would create significant problems for Novus, problems that we need to address before you leave. Have you thought about the impact on our product roadmap, on our investor relationships, on the team that depends on your technical leadership?" I had thought about all of that, had felt guilty about it, had almost let that guilt convince me to stay longer than I wanted to. But I'd also realized something important. My loyalty to the company didn't mean I owed them my career. "I have thought about it. I've provided 2 weeks' notice, which is standard. I'll document everything I can in that time and help with the transition. But I'm leaving." Catherine's expression hardened. "Let me be more direct. If you leave Novus, you'll be in breach of your employment agreement. The non-compete clause restricts you from working in diagnostic technology for 2 years. Stanford's position would violate that. The non-compete restricts commercial work. Stanford is academic research. That's not competition. Academic research that could lead to commercial applications. Our lawyers would argue that it violates the spirit of the agreement, and I'm prepared to enforce it." The threat was clear. Leave and face legal action that would make the Stanford position impossible, that would tie me up in litigation for months or years, that would damage my reputation in the industry. I'd prepared for this, had consulted with my own lawyer, who'd reviewed the employment agreement and confirmed what I'd suspected. The non-compete was aggressively written, but probably not enforceable for academic work. But legal fights were expensive and uncertain, and Catherine knew that the threat alone might be enough to keep me from leaving. Catherine, let's be honest about what's happening here. You're threatening to sue me to prevent me from taking a job that doesn't actually compete with Novus. That's not about protecting the company. That's about control. It's about protecting our investment in you. We've spent 6 years building Novus around your technical leadership. We've compensated you accordingly, given you equity, provided resources for your work. You have obligations that don't end just because you've decided you'd rather be in academia. That's when I realized she had no idea about the patents. No idea that the investment she was talking about had been built on technology I owned, that the resources she'd provided had been for developing improvements to my invention, that the equity I held was for a company that couldn't legally manufacture its products without my permission. Let me ask you something, I said carefully. When you've been pitching investors, how have you described the ownership of our core biosensor technology? We describe it as proprietary technology developed by our team. And the patents? We have an extensive patent portfolio covering our diagnostic platform. That's one of our key competitive advantages. Who owns those patents? Novus does, obviously. Why are you asking? I pulled out my phone, opened the folder where I'd saved the license agreement and the original patent filings. The foundational patents, the ones covering the core biosensor platform that everything else is built on, were filed by me while I was at the university. I licensed them to Novus when I joined as co-founder. The license is exclusive, but I retained ownership. Catherine's expression shifted from confident to uncertain. The patents are licensed to the company. The ownership structure doesn't matter operationally. It matters if the license can be terminated, which it can, with 1 year's notice, if I leave the company. Silence. I watched her processing the implications, realizing that the threat she'd just made, suing me to prevent me from leaving, would trigger exactly the outcome she was trying to avoid. You're saying that, if you leave, Novus loses rights to the core technology. I'm saying that the license agreement includes a termination clause tied to my employment. If I'm no longer CTO, I have the right to terminate the license after a 1-year transition period. I'd planned to discuss reasonable terms for continuing the license after my departure, but that was before you threatened to sue me for taking an academic position. Elena, you can't be serious. You destroy the company over this? I'm not destroying anything. I'm leaving to take a job that better aligns with my career goals. You're the one who turned it into a fight by refusing to accept my resignation and threatening legal action. I'm simply pointing out that you don't have the leverage you think you have. Catherine stood, walked to the window, looked out at the city below. The expensive office with the expensive view, all of it built on technology she'd apparently assumed the company owned without question. What do you want? She finally asked. Originally, to leave on good terms, to help with the transition, to negotiate a reasonable ongoing license for the core patents so that Novus could continue operating. But you just threatened to sue me to prevent me from taking an academic job. So now I'm not sure what I want. This is leverage. You're using the patents to extract something from me. No, Catherine. This is leverage you created by refusing my resignation and threatening litigation. I came here to leave professionally. You made it adversarial. Now we're both dealing with the consequences. She turned back to face me. We need to find a solution that works for everyone. I agree. Here's what I propose. I'll continue the license for the core patents under reasonable commercial terms. You'll agree that my departure doesn't trigger any legal action, and you'll provide a reference that's honest about my contributions to the company. In exchange, Novus keeps access to the technology that your entire business depends on. What terms? Ongoing royalty based on product revenue, 3% in line with industry standards for foundational technology, and public acknowledgement that the core biosensor platform was based on my original invention, properly crediting the IP source in your investor materials. 3% of revenue would be substantial. So would losing access to the technology entirely. You've built a company worth over $100 million on my invention. 3% is extremely reasonable compensation for continued access after I'm no longer here to develop improvements. Catherine sat back down, the calculation visible in her expression. The math was straightforward. 3% of revenue was expensive but sustainable. A lawsuit over the non-compete might win, but would trigger the license termination and destroy the company. Fighting over patent ownership would be even worse. She'd lose because the original filings were unambiguous, and the company would collapse while the litigation dragged on. I need to consult with the board, she said. Of course, I'm happy to present the situation to them directly if that would help. That won't be necessary. Give me 24 hours. I left her office, walked back to my own workspace, and waited. The company continued around me, engineers working on product improvements, the business development team negotiating with hospital systems, the operations team managing manufacturing partnerships. All of it dependent on technology I owned, none of them knowing that the company's continued existence was being negotiated in real time. Catherine called the next morning. The board would like to meet with you. Can you come in this afternoon? The board meeting was tense but professional. 5 directors sitting around the conference table, Catherine at the head. Me presenting the situation with the calm precision of someone who'd spent 6 years explaining complex technology to people who didn't understand the science. The core patents covering the biosensor platform are owned by Dr. Vasquez and licensed to Novus, I explained, showing them the original patent, filings, and the license agreement. The license terms include a termination clause tied to my employment. If I leave without a new agreement in place, the company has 1 year to wind down use of the licensed technology. I'd prepared a presentation, not dramatic, just factual. Slides showing the patent family tree, with my original filings at the root, and all the subsequent improvements branching from them. A timeline showing when each patent was filed, which ones I'd filed before joining Novus, which ones had been filed during my employment. Can we operate without the core patents? One director asked. No, Catherine admitted. Every product we make depends on the biosensor platform. We have patents on improvements and applications, but the foundational technology is Elena's. Without the license, we'd have to stop manufacturing within a year. Why wasn't the board informed about this risk? Because I didn't realize it was a risk, Catherine said. Elena has been here since founding. I assumed the technology was fully transferred to the company. I never thought to check the license terms in detail. It wasn't transferred, it was licensed. The distinction matters. Another director, Martin Hayes, a former pharmaceutical executive who'd always been one of the more technically informed board members, spoke up. Dr. Vasquez, walk us through your proposal again and help us understand the industry context for these terms. I'm leaving to take a faculty position at Stanford. I'm willing to continue licensing the core technology to Novus under commercial terms. 3% royalty on product revenue, proper attribution of the IP source, and an agreement that my departure doesn't trigger litigation over non-compete clauses that wouldn't apply to academic work anyway. And the 3%, is that standard? It's within the range of standard for foundational technology in medical devices. Royalty rates for core patents typically range from 2 to 5% of revenue, depending on how fundamental the technology is and what alternatives exist. Given that Novus literally cannot operate without my patents, 3% is on the conservative end. What happens if we don't agree to those terms? Then I exercise my right under the existing license agreement to terminate with 1 year's notice. Novus would need to either develop alternative technology that doesn't infringe my patents, which would take years and might not be possible, or negotiate with me from a much weaker position once the company is facing imminent shutdown of its product line. This feels like extortion, one director said. Richard Morrison, a venture capitalist who'd led the Series B round and had always been skeptical of what he called founder entitlement. This feels like contract enforcement, I countered. I filed the patents, licensed them generously to the company I co-founded, and worked here for 6 years developing the technology further. I'm not demanding anything unreasonable. I'm asking for fair compensation for ongoing use of my intellectual property after I'm no longer employed here. If I'd left the university and fully transferred the patents to Novus for equity alone, without the license structure, you'd be right that I'd have no claim. But that's not what happened. I negotiated a license that protected my IP rights specifically for this scenario. Martin leaned forward. Let me ask a different question. Why did you structure it as a license rather than a transfer when you joined? Because my thesis advisor told me never to fully transfer IP unless you're being compensated appropriately for its lifetime value. He'd seen too many academics give away technology to startups for equity that turned out to be worthless. He advised me to license with termination rights so that if the company failed or if the relationship broke down, I'd retain control of my work. Smart advisor. I thought so. At the time, Catherine and I had a good relationship, and I didn't think I'd ever need to exercise those rights. But it turns out having them matters, especially when your CEO refuses to accept your resignation and threatens to sue you for taking an academic job. The deliberation took 3 hours. I waited in an empty office, checking email, reviewing the Stanford offer letter, trying to imagine what my life would look like in 3 months, back in academia, doing research without quarterly earnings pressure, teaching students about the science I loved. Through the window, I could see the building across the street, another biotech company, probably full of people navigating similar tensions between science and business, between personal goals and company needs. The whole industry was built on that friction, on the creativity that emerged from trying to turn pure research into commercial products. I'd always known I'd return to academia eventually. The startup experience had been valuable. I'd learned about regulatory pathways, about manufacturing at scale, about what it took to turn a scientific insight into a product that actually helped patients. But I missed the freedom of academic research, missed working on problems because they were interesting, rather than because they fit a product roadmap. Catherine came to get me herself. The board has approved your terms. 3% royalty, proper attribution, no legal action regarding your departure. Our lawyers will draft the amendment to the license agreement. Thank you. I know this wasn't the outcome you wanted. It's the outcome we have. Elena, I want you to understand something. I didn't refuse your resignation because I was trying to control you. I refused it because Novus genuinely needs you, and I thought, incorrectly, that we had leverage to keep you. You had leverage. You just didn't realize it cut both ways. Clearly, for what it's worth, you built something remarkable here. The technology, the team, the products. None of it would exist without your work. I should have acknowledged that more explicitly, both internally and to investors. I'm sorry I didn't. It was the closest to an apology I'd heard from Catherine in 6 years. Not quite taking responsibility, but acknowledging a mistake. Better than nothing. I appreciate that. And for what it's worth, Novus has real value beyond my patents. You've built a strong commercial operation, established market relationships, developed applications of the technology that I never would have pursued on my own. The company will be fine without me as CTO. As long as we have the license? As long as you have the license, I agreed. The transition took 2 months instead of 2 weeks. Not because Catherine tried to keep me longer, but because I realized that a clean handoff would serve everyone better than an abrupt departure. I documented the technology thoroughly, trained my replacement, a talented engineer named Marcus Thompson, who'd been with the company for 3 years and understood the platform well, and helped the team understand where the product roadmap should go next. Marcus and I spent hours going over the technical details, the architectural decisions that weren't obvious from the code, the trade-offs I'd made and why. The kind of knowledge transfer that can't happen in 2 weeks, but that makes a huge difference in whether a technology transition succeeds. You designed this brilliantly, Marcus said during one of our sessions. The modularity, the way you separated the core detection platform from the specific biomarker libraries. It means we can develop new tests without touching the fundamental system. That was intentional. I knew from the beginning that the real value wasn't in detecting any specific disease, but in having a platform that could be adapted to detect anything. The challenge was building it in a way that let the business people develop new products without needing PhD-level expertise in nanoparticle chemistry, which is exactly what we've been doing. But I've always wondered why the particular nanoparticle formulation you chose. There are other options that look superficially similar. Surface chemistry. The gold nanoparticles with the specific ligand configuration I developed have binding kinetics that are fast enough for real-time detection, but specific enough to avoid false positives. I tested dozens of variations during my postdoc. Most of them didn't work well enough. The ones that did are covered by the patents. So, if we wanted to modify the formulation, you'd need to be very careful about whether the modification still fell under the licensed patents or whether you were straying into territory that would require separate licensing. That's something you should discuss with Catherine and the legal team as product development continues. The amended license agreement was executed in April. 3% of revenue in perpetuity for as long as Novus manufactured products based on the core biosensor platform. Proper attribution in all investor materials, explicitly stating that the foundational technology was invented by Dr. Elena Vasquez and licensed to the company, and a clean separation agreement that confirmed I was free to pursue academic research without any claims of competition or IP violation. I started at Stanford in June. The faculty position was everything I'd hoped: research freedom, talented students, the intellectual stimulation of working on fundamental problems without immediate commercial pressure. I published papers, filed new patents for work, developed entirely in the academic setting, and slowly rediscovered the part of myself that had been lost in 6 years of company building. The transition back to academia was both easier and harder than I'd expected. Easier because the rhythms of academic life, teaching, research, publications, conferences, felt natural in ways that board meetings and product launches never had. Harder because I'd gotten used to resources that startups take for granted. At Novus, if I needed a piece of equipment, I could order it. At Stanford, I had to write grant proposals and wait for funding decisions. But the trade-off was worth it. My research group at Stanford was working on next-generation biosensors that built on the same principles I'd developed for Novus, but pushed in different directions. Lower cost, higher sensitivity, different biomarker targets. I wasn't competing with Novus. The academic work was far enough from commercial application that there was no conflict. But I was advancing the science in ways that the company couldn't, because they were focused on near-term product development. My students were brilliant. I'd forgotten how energizing it was to work with people at the beginning of their careers, before they'd learned all the reasons why ambitious ideas might not work. They asked questions that challenged my assumptions, proposed experiments that I wouldn't have thought of, brought fresh perspectives to problems I'd been thinking about for years. The royalty checks arrived quarterly. The first one, covering April through June, was for $42,000. 3% of approximately $1.4 million in product revenue. Not life-changing money, but meaningful. The kind of income that made it possible to focus on research without worrying about academic salaries, that let me fund exploratory projects that might not attract traditional grant support. I deposited the check and thought about the mathematics of it. $42,000 for 3 months, extrapolated to $168,000 annually, more than my Stanford salary. Not enough to be wealthy, but enough to be comfortable, to have financial security while pursuing work I actually cared about. The check represented something more than money, though. It was validation that intellectual property rights mattered, that the invention I'd created had ongoing value, that the careful negotiation I'd done when joining Novus, protecting my rights even when it seemed paranoid, had been exactly right. By the end of the first year, the annual royalty had reached $180,000. Novus was growing, their product line expanding, and every dollar of revenue included my 3%. Not because I was extracting value unreasonably, but because I'd been smart enough, or lucky enough, to negotiate a license structure that protected my rights and provided for exactly this scenario. Catherine and I maintained cordial relations. She'd email occasionally with updates about the company, about products in development that built on the platform, about new applications they were exploring. I'd respond with suggestions, occasionally connect them with academic researchers who were working on relevant problems. The relationship had shifted from founder-CEO to inventor-licensee, but it worked. We had coffee once, about 8 months after my departure. She wanted to update me on the company's progress and to discuss a potential new product line that would require some modifications to the core platform. "We're thinking about expanding into veterinary diagnostics," she said. "Same basic technology, but optimized for different biomarkers and different regulatory requirements. Would that fall under the existing license?" "Depends on the specifics. If you're using the same core nanoparticle platform, just with different biomarker libraries, that's covered. If you're developing fundamentally new detection mechanisms, that might be outside the license scope. We'd be using your platform, just a different application, then it's covered. The license doesn't restrict you by market segment, only by the technology used. Veterinary applications are fine as long as you're not infringing someone else's IP in the process." "That's what I hoped you'd say. The market opportunity is substantial. Vets want better diagnostic tools just like human medicine does." "Makes sense. Just make sure Marcus and his team understand the technical constraints. The chemistry that works for human blood might need adjustment for other species." The conversation was professional, collegial, nothing like the tense negotiation we'd had in her office a year earlier. We'd both gotten what we needed. I had my freedom and my royalties. She had continued access to the technology. The arrangement worked because neither of us was trying to extract maximum value at the other's expense. 2 years after my departure, Novus was acquired by a larger medical device company for $300 million. The acquisition was based substantially on the strength of the biosensor platform and the product pipeline it enabled. Catherine called to let me know before the announcement. "The acquirer conducted extensive IP due diligence," she said. "They reviewed all our patents, traced the ownership history, and confirmed the license agreement with you. It wasn't a problem. If anything, having a clear license structure made them more comfortable, not less. They knew exactly what rights the company had. Congratulations, you built something valuable." "We built something valuable. The license terms transfer to the acquirer as part of the deal. You'll continue receiving royalties based on the same revenue percentage, just from a much larger company now." The mathematics of the acquisition changed everything. 3% of product revenue from a startup meant $180,000 a year. 3% of the same product line operated by a major medical device company with distribution networks and marketing budgets meant something closer to $600,000 annually. The acquirer had plans to expand the product line aggressively, to bring Novus's technology to markets that a small startup couldn't reach. Not startup founder wealth. Catherine's equity from the acquisition was worth tens of millions, but enough to live comfortably, to fund research, to have financial security while pursuing work I actually cared about. And unlike equity, the royalty stream was steady, predictable, not dependent on another exit event or another round of funding. I think about that Tuesday morning sometimes, about walking into Catherine's office to resign, expecting a difficult conversation, but not expecting to discover that I had leverage I'd forgotten about her refusal to accept my resignation and the threat of litigation that had seemed intimidating until I'd remembered the patents. She'd refused my resignation, thinking she had control, thinking the non-compete gave her power, thinking I would back down rather than face legal threats. She'd been wrong about all of it, and the discovery of that wrongness in real time had been fascinating to watch. But I also think about the fairness of it. I'd invented the technology, filed the patents, structured the license carefully when I'd joined the company. Catherine had built a business around my invention, hired a team, established market presence, turned science into commercial products. Both contributions mattered. Both deserved compensation. The 3% royalty wasn't punitive. It was fair. It recognized that foundational IP has ongoing value, that the person who creates technology that enables an entire product line should share in the success of that product line. That ownership matters even when it's separated from operation. Some lessons are expensive. For Catherine, the lesson cost 3% of revenue in perpetuity, millions of dollars over the lifetime of the products. For me, it cost nothing except the stress of the initial confrontation and the satisfaction of discovering I had leverage exactly when I needed it. But both of us learned something valuable. Catherine learned to check IP ownership carefully, to understand the terms of licenses the company depended on, to respect that intellectual property rights persist beyond employment relationships. I learned that protecting your IP when you're starting out isn't paranoia. It's prudent, and sometimes it provides exactly the leverage you need when circumstances change. The company survived, the technology thrived, the royalties continued, and I built a research program at Stanford that produced new innovations, filed new patents, and occasionally licensed new technology to companies, always with clear terms, always with protection for my rights, always remembering the morning when I'd walked into an office to resign and discovered I owned more leverage than I'd realized. She refused my resignation. I own the patents. Turns out that changes the conversation significantly. The city looks different now from my Stanford office. Less dramatic than the 41st floor view, but more honest somehow. Academic buildings instead of corporate towers. Students and researchers instead of board meetings and investor pitches. The kind of view that reminds you why you became a scientist in the first place. Some mornings I look at the quarterly royalty statement and smile. Not because the money matters more than the research. It doesn't. But because it's proof that protecting your intellectual property isn't just about fighting over ownership. It's about ensuring that if circumstances change, if relationships deteriorate, if someone tries to use leverage against you, you have something to negotiate with. Catherine thought refusing my resignation gave her power, the patents gave me more, and in the end, that made everything else possible.